jurisdiction, तो वो वही अफसर करेगा. Like your appeal is in Jaipur, that only अपने क्लाइंट को बोलो, तुम तो बोलते हो गाड़ियाँ गलत भेज दो, पैसे कमाए हम लोग. तुमको बोलो गाड़ी ठीक कर भेजा करो, जयपुर में ना आपको ले जाए. So be very clear that if you have an issue in Jaipur, how these issues arise. Supposing you get a notice from EDTI Panchkula. In case of Mr. Verma's case, your inquiry is happening, please come and show your books of accounts. You first have to see, do they have a jurisdiction? Answer is yes, they have the jurisdiction. You have to go there. Now supposing they tell you deposit so much money or we arrest you. You cannot come to Delhi and file appeal. Because the officer did not initiate any list against you. They did not issue you any notice. All proceedings will happen in Panchkula. Now supposing Delhi Commissioner wants to revise that order passed by a Panchkula officer, he cannot. Because all consequential proceedings in relation to that particular notice by a process of cross-empowerment shall be conducted by that team only. So it's a one-way affair. But that doesn't mean that Delhi wala bole main to Jaipur ki gaadi aap next. Stop it. Like I told you yesterday, once you file an appeal, now supposing the proper officer assessed you on 4 points. He did not take the issue of classification which Siddharth raised, whether these cufflinks are imitation jewelry or not. He also did not raise an issue that you did not reverse input tax credit. He also did not raise an issue that the refund was given to you erroneously. In view of the subsequent developments in the matter. Now all these appellate authority have the jurisdiction right under section 107, they can enhance your liability. That is, if section 73, 74 was not invoked by anybody else, they can invoke. This power was never there with any other authority in the initial act. PAT or state tax पर हमें नहीं थी ऐसी power. लेकिन इनमें इन्होंने उसको power दे दी. But the limitations in relation to those sections shall remain. That is, if he wants to invoke section 73, then the 3-year limitation remains from date of filing of annual return. उसको भी 6 महीने के अंदर नोटिस देना है. 6 महीने लिमिट देगा कि he cannot issue notice. So the appellate authority, when you go to him, it is also your job as a professional to ensure the client does not have any other issue. If he has an issue, advise the client, look, this issue, this I will reopen. अगर उसके ऑर्डर में ऐसा कुछ लिखा है और उसकी फाइल में ऐसा कुछ है, he can enhance your liabilities of tax, interest, penalties, both, all 3, provided he gives you a reasonable opportunity being met. That is, he will issue a show cause notice. So if you are going for appeal where your facts are not clean, where you think your client will be in further trouble if file the appeal, ask him to deposit and finish it up. So you have to do the cost benefit analysis of a particular strategy you wish to adopt for that particular client. You have to bother about it. Next. Appeal before tribunal. So it's not tribunal, but we will discuss briefly what tribunal means here. There are 4 kinds of tribunals here. One is a national tribunal, other is the regional benches of tribunal. Otherwise, the third is the state tribunal and the state branches tribunal. There are 4 kinds of tribunals. Only where there is a dispute regarding place of supply, national tribunal or the regional benches thereof shall have jurisdiction to hear appeals, nobody else. Because these are interstate transactions. You already have a central sales tax appellate authority. Just one in Delhi. So similar authority is there. If your case goes to national tribunal, depending on a jurisdictional matter, appeal goes to Supreme Court. If it's to regional benches, appeal goes to High Court. And the state level tribunal, again High Court. So if the assessment order shows 73, 74 or any other order shows there is a dispute regarding place of supply. Say for example, टैक्स का सेटअप करने के लिए इंट्रा स्टेट इंटरस्टेट में घपला कर दिया, टैक्स दिया आपने और आपके बिल देखते हो कहते हैं सर ये तो इंटरस्टेट सप्लाई इंटरस्टेट तो है ही नहीं, यू कुड नॉट हैव एडजस्टेड इन सेक्शन 49, it creates a demand. There is a big problem. Though in IGST Act by way of section 20 you can apply for the refund, but this is not a stage where you can claim refund because your liability still has to be determined. If you agree to pay tax, you can get that refund, but you lose interest. But if you want to contest, you have to go to regional bench or national bench depending on where the particular rules come and wherever it's to be appealed against, we don't know. So if an officer has raised an issue of place of supply, the state tribunal jurisdiction is finished. You have to necessarily go to regional bench or national tribunal or the national tribunal. If it is not a place of supply issue, then the local tribunal shall have jurisdiction. And GST will have 90% cases disputes regarding place of supply. Export of services a place of supply issue. इंटरस्टेट ट्रांजैक्शन है या नहीं है तो कुछ है नहीं इसमें। तो जो आपके लोकल झगड़े हम शुरू में कर रहे थे, when we were reading section 8 section 10 IGST Act, what is the intrastate supply, that be section 7, तो उसमें हमने देखा था कि इसमें कितना बड़ा कंफ्यूजन है। फॉर एग्जांपल बिल टू शिप टू ट्रांजैक्शन, if you are doing within the state no issue, but you are involving 3 parties from 3 different states, these are issues of place of supply. किसको jurisdiction कहाँ था, किसको इनपुट टैक्स क्रेडिट मिलना है, what if on examination your bill to ship to transactions are rejected, and if it's not only a Delhi party, then it's a place of supply issue, you go to a particular tribunal. The first appeals may still lie here, but when you go to tribunal, these tribunals will have jurisdiction to hear the appeals. We are not talking of first appeals. Here also there is a deposit of 20% in addition to 10%. I recently came across a case where an opinion was sought from us, a very pure legal issue. They got an exemption of around 5 crore rupees tax based on a particular notification, right? And the first appellate order was passed. Now they get a notice, you know, this exemption was wrongly given to you, therefore we want to recover it. Now the question comes, if you want to challenge before tribunal, is it admitted tax or not? If it is admitted tax, you have deposited 5 crores. In addition to 20% of the balance tax amount. If you say this is not an admitted tax, then you dispute this. Supposing, as we all will do, we will dispute this. कि ये notification गलत है, ये गलत है, but tribunals cannot decide the issue on notifications. They are a creation of a statute. The statutory authorities cannot interpret a notification against the revenue. Therefore, this is a close call for the chartered accountants or advocates to take. Under these circumstances, is this tax to be admitted or disputed? Supposing a notification based on which you took the exemption is cancelled retrospectively, then can you say this is a claim you can dispute? The answer is no. So again, depending on facts. So there also you have to be very careful when you talk to your client. That's why when you file appeal, your fees should be 10 times. Appeal is a very special remedy in any given law. Like when you take registration, जो लोग फ्री करते हैं, मेरे को तो बड़ी हैरानी है कि वो किस तरह के लोग हैं, बिल्कुल बहुत ही घटिया किस्म के प्रोफेशनल जो ये काम करते हैं। पीछे बसों में लेके 500 रुपए में रजिस्ट्रेशन सर्टिफिकेट, 4 दिन में गारंटी। तो प्रोफेशनल नहीं है वो, प्रोफेशनल है। I know two girls who are chartered accountants. One approached me, I told you Anita Part. I'm giving her name. मुझे कहती है हमारे आरसी कैंसिल होंगे तो आप कितने पैसे लेंगे? मैं कि जितने तुमने सारे साल में रिटर्न कमाए उसमें हमारे एक केस की फीस है, मेरे हम दुकान लेंगे जब क्यों मुझसे जानता है वो कोई बुक पे लिखती थी 500 रुपए में रिटर्न सर्टिफिकेट। क्वालिफाइड सीए सर, नॉट सीए, फेक नहीं है। अनक्वालिफाइड सीए नहीं होता। देख रहा था ना, तेरे को सीए से प्रॉब्लम है। पता है कितने फेक एडवोकेट हैं हमारी बार में, कितने होंगे? इन्होंने एक बार एक्सरसाइज की थी, ये सीए भी बड़े फेक। और डॉक्टर को तो पूछो मत कितने फेक हैं। सुप्रीम कोर्ट में प्रैक्टिस करते थे वो वकील फेक है, क्या बात क्या है? कितने केस हुए सुप्रीम कोर्ट में? दे वर नॉट एडवोकेट्स, है ना वहां, इंग्लिश तुमको आती थी बोलनी। तो सीए तो कॉस्ट अकाउंटेंट तो बड़े, अभी पीछे जो कुछ दिन पहले सीए केस हुआ है ना, तो कहते हैं मेरे आई डोंट नो हु इज ही, वो सीए फेक था। ये जो 7 करोड़ का झगड़ा पीछे पड़ा है तो पकड़ेगा फेक सीए। फेकिज्म इज अ पार्ट ऑफ लाइफ। मेरा अपना एक बड़ा जिगरी यार है यहाँ पर, ही इज अ लॉयर, आई एम श्योर ही इज अ लॉयर, आई डोंट नो। He used to tell the authorities I am Mr. Verma's partner. और मैं कभी वार्ड में आज तक गया ही नहीं। I have never been to any ward ever in my whole career. मैंने कभी सेंटेक्स नंबर नहीं लिया, कभी किसी को फॉर्म नहीं दिलाए, कभी असेसमेंट नहीं कराए, कभी एनफोर्समेंट केस नहीं कि मेरे मन के केस नहीं करता। So that's not a part of my temperament. तो मैं लेक्चर दे रहा था तो उस वक्त मेरे को लगा ये तो मुझे आपके पार्टनर है, मेरा पार्टनर तो बन ही नहीं सकता, भूखा मर, तो मैंने काम ही नहीं करता तो वैसे कहाँ कराएगा वो? कहते नहीं पिछले 2 साल से वो केस करा रहे हैं, इसका यू नो दी वर्तन 2 साल से वो केस करा रहा है। सुनो, you will know. So you have to take a call under these circumstances where information has been withdrawn retrospectively, or there is a jurisdictional high court ruling or a Supreme Court ruling which says that this assumption was unwarranted and illegal. Now you have to take a call if you have to go to tribunal. What stand you take for this note? High Court आपके खिलाफ है या Supreme Court आपके खिलाफ? Will this text be admitted? But this is a big question because law says in addition to 10% or 20%, you have to deposit the tax, interest, penalty that you admit. उसके अलावा आपको 10% जमा करना है। और ट्रिब्यूनल का वो 25 करोड़ क्या है, 50 करोड़ क्या है, लिमिटेशन क्या है अभिषेक? 25 करोड़ नीचे है, 50 करोड़ मेरे का ट्रिब्यूनल है, जैसे अपर लिमिटेशन, उसके बाद आपको पैसे जमा नहीं कराना है। ट्रिब्यूनल में एक और कंसेप्ट है, डिपार्टमेंट को उन्होंने 2 राइट दिए अपील करने के। फर्स्ट अपील, नॉट वन। Once an appeal is filed by the taxpayer before the first appellate authority or the tribunal, before the tribunal, department has the right to file cross objections. Cross objection है कि जहाँ तो उस अपील के, जहाँ on those issues which were not raised by the assessing authority, those issues can also be raised by way of this process, and this has to be done within 45 days from date of filing of appeal by the taxpayer, and it can be further condoned by 45 days or whatever the period is. That is, अगर जब आपने अपील फाइल की, you have to be careful कि department can file objections. Supposing they file on 46th day without condonation, don't jump, keep quiet. Just don't discuss with anybody. Once the case comes to hearing, because law says once the department has filed its objection period, this shall be deemed the appeal before tribunal. जैसे क्रॉस अपील, लेकिन अगर उन्होंने 46 दिन फाइल किया है, आपको जंप नहीं करना। हियरिंग पे बोलो दिस इज टाइम बार्ड, तब बोलो दैट इज ए लॉयर स्ट्रेटजी। डोंट ओपन योर कार्ड बिफोर द कोर्ट ओपन्स, तो टाइम बार्ड है। Now tribunal will have no power to give them time because of 45 days may have been over. So tribunal cannot condone. That means their appeal, the cross objections are dismissed at the threshold, finished. Now they deal with your appeal. Now in section 108, Commissioner has one more power. Commissioner can call for any order passed by the subordinate, including other than revisional authority, to examine the section 263 income tax subordinate revision, same language, to examine the propriety, illegality or justification of the order passed by subordinate officer. And if he comes to a conclusion that these orders were wrongly passed, he can review the order and mention the grounds of appeal before the tribunal and send it back to the statutory. Please file appeal before tribunal. In that review order, he will also mention the grounds of appeal. from the date when such order of commissioner is communicated to the officer gets 6 months time to file the appeal, or 3 months or 6 months, we will just see it. I don't know. उसमें भी condonation है. So you are now they got two rights. First, they can file objections. Then commissioner can also file a second appeal under certain circumstances. If he is aggrieved कि जो नीचे वाले जो order pass किए हैं वो गलत है, certain legal issues were not taken by them. Let's read this now. आगे चलो. Next. Concept of objection introduced. The law also provides for filing of objection by the respondent against such part of the order against which the respondent may initially not have chosen to file the appeal. The commissioner may not have filed the appeal at all. It's provided that on receipt of notice that an appeal has been filed by the appellant, the party against whom the appeal has been preferred may, notwithstanding that he may not have appealed against such order or any part thereof, file within 45 days a memorandum of gross objection against any part of the order appealed against, and such memorandum shall be disposed of by the appeal tribunal as if it were an appeal presented within time specified for the initial appeal. So this is first right of appeal given to backdoor to the commissioner. कि आपको कोई बॉर्डर में गड़बड़ लगा है, एक 4 पेज लिख दो, जो भी बकवास लिखना है एक बार लिख के डाल दो. Confuse the tribunal. ये सारा ऑर्डर गलत पास किया है, हम we are also viewed by this order. So as now this objection when filed within the limitation period, appellate tribunal shall take them as an appeal by the respondent, that is the commissioner. Condonation delay appeal applies here also, but only to the extent of further 45 days. So अगर आपके पास क्रॉस ऑब्जेक्शन आते हैं as a professional, you have to first see when did you file the appeal. Let us say on 1st January 2022. Then up to 15th February this cross objection should have been filed. If there was no fight, these are timelines. Don't open your mouth at all. Don't go to government council. क्या कर रहेगा था? टाइम बार फाइल कर दिया तुमने? 45 दिन उसका पैसा भी ओवर है. वो condonation लगा दे. Normally a condonation application should go with the appeal, but there is no law that prohibits that within the limitation period prescribed for condonation, a condonation application cannot be filed. Even the court can permit. क्या आप एक application file कर दो, we will not delay. And होता है, सारे कोर्ट करते हैं. Normally अगर 45 दिन के बाद किए गए तो एप्लीकेशन के साथ जानी चाहिए थी, जैसे हमारी अपील के साथ जाती है, राइट. लेकिन अगर आपकी अपील फाइल हुई और 1 महीना निकल गया, उसके बाद तो एप्लीकेशन फाइल कर ही नहीं सकते. इट विल डिसमिस द थ्रेशोल्ड इस टाइम बार. तो जहाँ भी ऐसे ही है, अगर आपको लगता है कि ये टाइम बार है, आप चुप रहो. जब केस में आए देन टेक एन ऑब्जेक्शन. नाउ सिंस लिमिटेशन गोज टू द रूट ऑफ द मैटर, the tribunal can have no jurisdiction to waive this condition. Tribunal can take this appeal, as an appeal for disposal, only when these objections are filed within 45 days of filing of appeal by the taxpayer. अगर नहीं है तो 45 दिन और है. ट्रिब्यूनल को 91 दिन का कोई इसके बाद कंसेप्ट नहीं है. So then he will dismiss the cross elective filed of that not maintainable in view of their time bar, and then proceed to hear appeal of the taxpayer. One day more. पर इसमें disputes हैं. The word is within 40. Depends on the language of the statute. But more or less it's a gazette hold day. अगर वो 45th day gazette था, तो 1 दिन होगा. But the gazette day should be 45th day. Then it's within 45 days. Then 1 day will be more.
General class is that.
हाँ जी. नहीं अपील तो कमिश्नर फाइल करेगा ना क्रॉस ऑब्जेक्शन. Copy will be served upon you. I'll with it. Let them not give a copy. 45 days remain ना. ट्रिब्यूनल में ठप्पा मारेगा ना कब मिला. Unless they can go and get a backdated stuff. Possible नहीं.
सब computerized है.
सब computerized. This objection you can raise any time. Even in Supreme Court, you can raise this issue of limitation. So this goes to the root of the matter.
Legal issue.
It's a pure legal issue. 45 दिन थे या नहीं? इसमें कोई इंक्वायरी नहीं है. It has the power to remand the matter. First appellate authority had no power to remand the matter, but tribunal can remand the matter. Otherwise, they can confirm, enhance, or whatever they can do. Next. Now, in section 112, a power has been given to tribunal if 20% which was a pre-deposit was made by the taxpayer for the entertainment of the appeal, in addition to 10% of deposit which he made initially. That is, पहले आपका 5 लाख डिस्प्यूटेड टैक्स था, आपने 50,000 में जमा कराया. आप जब ट्रिब्यूनल में जाएंगे आपको 1 लाख रुपए और जमा कराना. तो आपका टोटल कितना हो गया? 1.5 लाख रुपए. If you win the appeal, tribunal has the power. He will write in the order amount be refunded with interest. It's a mandate to the tribunal. If an onerous condition was put on the taxpayer, now you raise the wrong demand, pay interest, and interest will be paid from the date when you deposit the money, not like daily VAT or daily sales tax.
Date of order से नहीं, date of
No, date when you deposit. If you read this, section shall be payable from the date of payment of the amount and not from the date of the order of pay or tribunal till the date of payment of such amount. So it's a mandate here now in section 112 dealing with appellate tribunal that tribunal while accepting the appeal shall also order the refund of the deposit. So what does this mean for you as a lawyer? There's a huge responsibility. आपको जो नीति पैसे जमा कराए उसका भी चालान लगाना है, वो भी लिखना है कि हमारी पहली अपील हुई थी, हमने इतना अमाउंट डिस्प्यूट किया था, ये एडमिट जमा कराया था, राइट, ये हमने 10% चालान है, नेक्स्ट है, इसका 20% नोट करा रहे हैं. Therefore the total pre deposit made up to tribunal is so much amount, so that tomorrow when you win, otherwise tribunal का डिमांड नहीं मैटर. डिमांड में से लाओ 10% पैसे दो, हम रिफंड नहीं देंगे वरना. You want a clear order? Mention all the facts. ट्रिब्यूनल में जब ट्रिब्यूनल में अपील फाइल करते हो, जो नीचे आपने ग्राउंड दिए उसकी कॉपी भी साथ लगानी है आपको. It's not required by law, but it's a piece of advice for a
generally they ask for it.
So they cannot. आपका ट्रिब्यूनल मानता है, कोई नहीं मानता, आपका ट्रिब्यूनल मानता है. इसलिए हिंदुस्तान में कोई ट्रिब्यूनल नहीं मानता.
ये तो आगे बढ़ते ही नहीं.
तो अब
सर जैसे डिपार्टमेंट का 45 डेज का टाइम है अपील फाइल करने के लिए, और उसके बाद 45 डेज का और कंडोनेशन हो सकता है, तो वो भी कंडोनेशन भी डिपार्टमेंट में 45 डेज में ही अप्लाई करनी चाहिए, और नहीं होती है तो
टाइम बाद फिनिश्ड. अगर आपका पास जब कॉपी आई वो 45 दिन के बाद आई है तो आपको मुंह बंद रखना, मतलब लेडी होगा भी मुंह बंद रखना, इस पे नहीं बोलना.
डेट मुझे मतलब 45 डेज का 45 डेज लैप्स हो गए और हियरिंग डेट मिली नेक्स्ट 10 डेज में, ठीक है. तो नहीं सर टाइम बार नहीं हुआ, मैंने फर्स्ट 45 डेज में हमें उन्होंने नहीं लगाया.
You can take objection of time bar. Yes. जब उन्होंने application लगाई तो time bar. Then you insist that now you cannot be given opportunity to file for counter application. Tribunal will take the jurisdiction, but you should vocify strongly argue this matter.
कहीं ऐसा तो नहीं वो कह देगी नहीं कंडोनेशन लगाने.
हाँ, there is that. अगर time है तो there is. And you should mind.
तो legally वो तो right
Legally the right तो उनका है ना.
Nobody can debar that right from them.
Next please. Now this is what I was telling you. Let's read this two paragraphs, second and third. I have explained that to you, but this the law says. The GST law provides that in such cases the department can file what is formally known as a review appeal. The GST law gives to any order passed by his subordinates acting either as appeal or review mechanism of GST as an adjudicating authority or the appellate authority or revisal authority. Now, you know the meaning of adjudicating authority? You know the appellate authority, you know the revisal authority. The revisal authority can be appointed or authorized, whereas adjudicating authority, appellate authority are formally authorized, not appointed. If the commissioners of the view that any order passed by such authority, that is the other three authorities, are not legal and proper, he can direct any officer subordinate to him to apply to the competent authority. For example, if the order of adjudicating authority is reviewed he can order his subordinate to file an appeal before the appellate authority. If the order of the appellate authority or the reviewing authority is reviewed, he can direct his subordinate to file an appeal before the tribunal. The grounds for appeal will be mentioned in his order. The review of the order and the consequent filing of appeal by the subordinate has to be done within a period of 6 months from the date of publication of the order. I explain that to you. This is a part of section 108. So commissioner has omnipotent powers. आपका रिव्यू कर सकता है, रिवाइज कर सकता है, can file cross objection, and he can also review and tell the subordinate to file an appeal. Whereas you have only one right to file appeal or a second appeal. Next. Next. Who is the revisional authority? Since a revisional authority review order can also be review oblique appeal based on direction of the commissioner, then we have to know who is the revisional authority. Supposing commissioner himself is the revisional authority, then what happens? He cannot. The revisional authority has to be subordinate to him. Is commissioner subordinate to himself? The law says subordinate who is an appellate authority, adjudicating authority, revisional authority. When he delegates his power to some other officer to act as a revisional authority if the law permits. Like here our commissioner is 74 capital A, he was the supreme revisional. We have done so many cases, I have done high court, Rajesh has done high court cases. So उसमें वो since he himself authority, he cannot do that by his definition. Authority and authority authorized under this act for the revision of decision or order drafted in section 108 of the act authorizes such revision authority to call for the examine any order passed by the body under the case of so far as this is prejudicial to revenue and it's illegal. Now ये जो आपका ये dark area है, this finding has to come in the order. You cannot quote this section say order reviewed. You can straight take to high court. This is very bad in law. That is, commissioner has to show when can a revisional authority review this order? Only when this order is revenue and illegal or improper has not taken into account certain material facts.
Form the opinion.
He has to give this finding based on the following facts. I think this order is against the revenue or material facts are. इसकी लैंग्वेज 263 से अलग है, प्रिंसिपल इसे 263 की ये लैंग्वेज नहीं है इनकम टैक्स में, तो हजारों जजमेंट है सुप्रीम कोर्ट की. Now it further says whether available at the time of issuance of said order or not, or in consequence of an observation by the CAG of India, he may necessary he can revise the order. Now this is a sweeping power given to him. ऑर्डर में लिख रहा है गुंजन का टैक्स 10 रुपए, उसको बाद में कहता है नहीं वो इला करके कंप्लेंट की गुंजन की इस पे टैक्स 50 रुपए होना चाहिए, वो ठीक बोल रहे. Now this is a fact divorce the earlier order. और सीएजी कहते हैं ये जो गुंजन मैडम है इन्होंने अपने रोक से ऑर्डर कराया है 10 रुपए का, इसको 10,000 टैक्स लगना चाहिए था. So far the law was the auditors' opinions are not a ground for so much appeal. But in order to cut short those of Supreme Court rulings, they have nullified them and amended the law. So on these grounds also, this order, revision authority and appointed in section 299 can review the order. Next. Now, when can revision authority not pass the order? Like there are non-appealable orders, there are also orders which cannot be subjected to revision and now this is interpretation. These 4 lines are very, very critical because you are going to face this. Lot many cases are coming up. Maharashtra में शुरू है, हमारे यहाँ में शुरू नहीं हुआ. The order has been subject to an appeal under section 107 or 107 first appeal, 112 tribunal, or under section 117 High Court, 118 Supreme Court. Subject to an appeal. So when is the appeal have been filed? When you have got an acknowledgement. You cannot say जी मैं हमने appeal file करनी है, मैं time दे दो. Then your order can be revised. When you deposit 10%, completed the part of procedure, 3 certified copies, and you got the acknowledgement, then only then you are deemed to have filed appeal. If you have done so, then commissioner cannot so much revise only if the matters are pending under these 4 sections only. If your section में you can revise, right? the period specified thereunto has not yet expired and more than 3 years have expired after the passing of the decision or order sought to be revised. 3 महीने अभी खत्म नहीं है और 3 साल हो गए हैं या और ऑर्डर sought to be revised में रिवाइज नहीं कर सकते. That is, आज ऑर्डर हुआ और कमिश्नर केम टू नो द मिस्टेक और इसमें भी 3 महीने अपील के लिए 3 months not 4 months. The statutory limitation is 3 months. 1 month is not a part of statutory limitation. Especially condonation given to the appellate authority. तो अगर 3 महीने नहीं बीते हैं तो कमिश्नर का ऑर्डर इज विदाउट जुरिसडिक्शन. जहां उस ऑर्डर को पास हुए 3 साल हो गए, जैसे हमारे 3 years, किस ऑर्डर को पास हुए 3 साल हो गए तो सुमो रिवीजन कैन नॉट हैपन, बट दे स्टिल हैव द प्रोविजन अंडर सेक्शन 74 वो 5 साल. These 3 years from date of order, not from date of annual return.
तो जो 3 महीने का वो एक्सपायर हो गया तो 3 साल की कंडीशन क्यों है?
कह रहे हैं अगर 3 महीने हैव नॉट एक्सपायर्ड, 3 महीने खत्म नहीं हुए, जहां ऑर्डर हुए 3 साल हो गए तो दोनों केस में वो सुमोटोराइज नहीं कर सकते. डिविजनल अथॉरिटी कैन नॉट एक्ट. और द ऑर्डर हैज ऑलरेडी बीन टेकन अप फॉर रिवीजन अंडर दिस सेक्शन एट एनी अर्लियर स्टेज. सेंट्रल लॉ देयर कैन नॉट बी 2 रिवीजन अगेंस्ट द सेम ऑर्डर. तो अगर पहला रिवीजन उस ऑर्डर का हो चुका है, ही कैन नॉट रिवाइज. तो लाइक in appeal there were non appealable orders, here also we say there are orders which cannot be subjected to revision, they can exist. This you can go through yourself, form fill up देखना. आगे चलो या इससे पीछे चलो. Let's spend 20 minutes on the first time discussing judgments. Higher fee deposit. Once a statute prescribes 10%, no authority can ask you to deposit more than 10%. Not even Supreme Court. Not even under extremely bad circumstances. If it is exercise order of appeal, 10%, remaining demand due to have been stayed. Next. These are judgments, 7 judgments you can read. Basically they are saying the same issue, that if the period of condonation prescribed under the Act or the Limitation Act has been excluded, then there is no power given to any court or authority to condone the delay. For example, first one. Now again, when you say these judgments are under arbitration or some other act, like I told you, if they are laying down a general principle of law, then notwithstanding under what act these judgments are passed, it's equally relevant for GST tax laws also. Where the legislature prescribed a special limitation for the purpose of appeal and the period limitation of 60 days was to be completed after taking the aid of section 4, 512 Injunctive Act. The specific inclusion of these sections meant that to the extent only the penal Injunctive Act stood extended and the applicability of the other provisions by lesser implication stood excluded. You cannot invoke any other section to condone this. NGC, where the statute commands that the court shall not condone the delay beyond a particular date. In other words, can condone delay up to a particular date and not beyond that. It would come within the ambit and sweep of the provisions and policy of the legislation. Therefore, it is uncondonable. अगर 1 महीने का टाइम है, 45 दिन का टाइम है, 3 महीने का टाइम है, कंडोनेशन का 6 महीने का टाइम है, then these periods are uncondonable. Not even Supreme Court can condone this.
यही है एक्सपोर्ट में भी
बहुत सारी जजमेंट जो मेरे खाते पड़े थे, मैंने काफी कर दिया. नेक्स्ट. Now this is a paragraph quoted in ONGC case. It's a very good paragraph. And an identical question came to be considered by constitutional bench of Supreme Court in the case of Hilly Multipurpose Court Storage. The question before the constitutional bench was whether the district forum has the power to extend the time for filing of response to the complaint. What was the matter? Complaint ही उसका जवाब दाखिल करना है आपको 15 दिन में. सुप्रीम कोर्ट का कॉन्स्टिट्यूशन बेंच इसको डिबेट कर रहा है. कंप्लेंट का जवाब देना है, कोई टैक्स वैक्स नहीं है वहां पर. Beyond 15 days, in addition to 30 days, as approving the decision of court in this case of JJ Tho, and after considering the various the bench has ultimately concluded that the district forum has no jurisdiction and or power to extend the time of filing of a response to the complaint beyond 15 days. And this more than 17 judgments of Supreme Court were debated by this constitutional bench. But they still came to the conclusion, कंप्लेंट हुई है 15 दिन में आपको जवाब डाउरी केसेस में ऐसा होता है, वहाँ लिमिटेशन है, अगर आपने जवाब नहीं दिया तो यू कैन क्वेश्चन सॉल्व होगा। दिस वाज सच ए पेटी मैटर अकॉर्डिंग टू मी। तो किसी ने कंप्लेंट किया ये बंदे ने चोरी की है, कहते जवाब 15 दिन देना चोरी की है या नहीं की है। You know, you can laugh. I can tell you a little joke on law point. There was a federal court, a case of a thief was going on. ईलागर जैसी थी, बड़ी शातिर दिमाग की वकील थी। उसने कहा जज सेज ओके आई एक्सेप्ट ईलागर आर्गुमेंट, यू आर एक्यूटेड। अब वो चोर था, वो बहुत पागल आदमी था, कहते हैं माय लॉर्ड दैट मींस आई कैन कीप द मनी नाउ। आई कैन कीप द मनी नाउ। तो वही हाल ये है कि वकील कहते हैं अरे भाई हम डिले करवा लेंगे कंट्रोल। नेवर एवर गो अगेंस्ट लॉ। टेल योर क्लाइंट के बडी यू हैव 30 days, यू कम इन टाइम और इट्स ऑल गॉन। तेरे पेपर बाद में फाइल कर सकते हैं, एटलीस्ट मूव इन टाइम। डिफेक्ट कैन बी क्योर्ड, कोर्ट हैज द पावर टू गिव यू टाइम टू क्योर द डिफेक्ट, बट फाइल व्हाटएवर फॉर्म यू वांट टू फाइल। एप्लीकेशन फॉर अमेंडमेंट, दैट एप्लीकेशन विल बी अलाउड। लेकिन जो काम आपको लिमिटेशन में करना है आपको हर हाथ में करना है। नेक्स्ट नाउ दिस इज a 7-judge judgment of Supreme Court, Bengal Amenity. It's a tax judgment. We need not go into it, it's not relevant now. It was heard by a constitutional bench of this court that if there is any hardship, it is for the, why have chosen judgments differently, so that all viewpoints you may have, कि अरे बड़ा हार्श है यार, बंदा मर गया, जी गया, क्या हो गया, कोर्ट बॉदर नहीं करेगा। सपोज चाहिए मैं प्रोप्राइटर था, प्रोप्राइटर वाज डेड, कौन करता? कोई नहीं करता। टैक्स दो। This court that if there is any hardship, it is for the legislature to amend the law, and that the court cannot be called upon to discard the cardinal rule of interpretation for the purpose of mitigating such hardship. If the language of an act is sufficiently clear, that is, you cannot apply Norris' rule here. Sufficiently clear, the court has to give to it, however inequitable or unjust the result may be. The words dural acts ad lex, which means the law is hard, but it is the law, may be used to sum up the situation. Therefore, even if a statutory provision causes hardship to some people, it is not for the court to amend the law. A legal enactment must be interpreted in its plain and literal sense, as that is the first principle of interpretation, which is yesterday. Literal rule: if language is unambiguous, clear, there is no further interpretation required. Existing generous reasonable construction comes later if there was some defect in the language of the enactment, which can be interpreted. But like here, you will not condone delay beyond 1 month. It doesn't require any interpretation. Next. Yeah, this is another observation made by constitutional bench. I put it for you. That inconvenience is not a decisive factor to be considered while interpreting a statute. In Martin Bun, so and so, this court, while dealing with the same issue, observed a result flowing from a statutory provision is never an evil. हम ही कहते हैं बड़ा घटिया लॉ बनाया, क्या कर दिया? कोर्ट से में हो, it's the law enacted by
legislature,
by the parliament or appropriate legislature who has the power to do it. A distress resulting from its operation, a statute must be of course be given effect to whether a court likes the result or not. You should remember this review case of Northern India Theatre case done by
Danny Kalsiwal. अरे वो जिंदा यार।
चलो वो कोई था, तो वहां सुप्रीम कोर्ट के बोला था कि had you taken this point at the initial stages, it would have been different. It's on page 45 STC 212 this paragraph. सुप्रीम कोर्ट ने बोला जो आप रिव्यू में आर्गुमेंट ले रहे हो, अगर पहले लिखे होते तो केस आप जीत गए थे। We are bound by review to show error apparent on the face of the order. We have not been able to show any error. These are subsequent developments which we cannot take into account. So court will not bother. हमें कहते हैं कि सर मर्सी कर दीजिए, बंदा मर जाएगा, जी जाएगा, इनका फैमिली खत्म हो जाएगा।
Even in L&T case, NCT Delhi, they simply wrote this provision is not there in the state act. Legislature may take up at a later stage to amend this to keep it in consonance with the API.
Again, Supreme Court has observed that when legislature has clear intention of not condoning delay or not providing large amount, the same cannot be obliterated by reading something else in the statute, taking recourse to section 5. Now there are two sections of Limitation Act which I will tell you yesterday. We'll spend 5 minutes. Section 5 is a Law of Limitation Act, which says if delay is caused by sufficient cause, courts have the power to condone delay, provided the Limitation Act is applicable to that particular act. Then there is section 29, subsection 2 of Limitation Act. There is a celebrated judgment of Mukri Gopalan versus Union of India. If you have interest, please read Mukri Gopalan versus Union of India. You can read the head notes also, that will be sufficient for your knowledge. In this, the 3-judge bench passed a very Gopalan versus Union of India. The 29(2) says, if the period of limitation or the provisions of Limitation Act have not been expressly excluded with tax law, the Limitation Act will be applicable, notwithstanding the fact it is not invoked. Now the question there was whether in this kind of language what we have in GST law, can we say that the Limitation Act has been specifically excluded? Courts following Mukri Gopalan have held, yes, the intention is clear, not to condone delay more than 30 days. Therefore, this is specific exclusion of Limitation Act. In express words, the Limitation Act not applicable. The court said the language of a particular statute shall determine whether Section 5 or Limitation Act giving power to the authorities, including special authorities.
Yes, the section is very much clear.
Prosecuting the petition against the order dated 13 for the Commission of Service Tax has to be excluded. That is, if you apply to a wrong forum or you don't get relief for the same relief, for example, you are advised to go to High Court. Like this girl Sapna was asking me, can we go to High Court? Suppose you go to High Court, High Court says no, we have no jurisdiction. If you went within 3 months, then the entire period shall be excluded. It can be 1 year, 2 years, 3 years, 4 years. Whatever was left to finish 3 months, that is, you went on at the end of 2 months, 20 days. You still have 10 days time. That 10 days time is still available to you when you get the order from a particular authority giving you leave or not giving you. Next, please. Next, same thing. These are judgments on minimum deposit. There are 4 judgments you can read. I may not read it. They say the courts have no jurisdiction to interfere with this. Now the question comes, is it a Bible written by the law? Unless you deposit 10%, you cannot go to High Court. You cannot approach. Answer is no, you cannot. Orders without jurisdiction. If you show orders against a Supreme Court judgment, if you show the order was passed without a show cause notice, that is without following the natural justice or a due process of law. If you show order was passed on a holiday, if you show that all the replies filed by you were not considered, or you show the order is biased, the issue was prejudged, courts will interfere, notwithstanding whether you file the appeal or not. And in GST, many courts have interfered.
But again, that period of limitation will arise.
उसमें आपको मिल जाएगा सेक्शन 14 का रिलीज तो मिलेगा. In Swiggy's case, in Radhakrishnan Industries case of Supreme Court under Section 83, what happened? A Himachal commissioner passed an order of attachment. They went to writ. He went to High Court, dismissed the writ case, no go to appeal. Matter got to Supreme Court. Supreme Court examining the scheme of CGST Act. They say, who can file the appeal against whom? Appeal can be filed against an order of adjudicating authority. As we know, adjudicating authority does not include commissioner. If commissioner passed the order in Section 83, where is the first appeal? there's no tribunal, he has to go to writ. Right? And then they said that the order is such where in any case it was maintainable. They quashed order, passed strictures against Himachal Pradesh High Court, and they passed a classic Section 83 guideline. In Swiggy's case in Bombay High Court, where they collected more than 50 crores by coercion during raid at Swiggy's place, and they went to High Court. They appeal for what? Did you collect tax? Did you raise a demand? तुमने चक्कू रखे उनके पैसे ले लिए? They said no, and they file appeal when we create demand they can adjust. कहते so you collect advance tax to be adjusted against future liabilities. High Court without determination. Therefore, High Court did entertain the writ petition. In two of my recent cases, on September issue of ITC limitation, we made out a case. They stayed the show cause notice. They did not tell us to go and appeal. In any case, there is no appeal against show cause notice. This is not an order at all. There has to be an order or decision. A show cause notice is neither an order nor a decision. Therefore, given the circumstances of a particular matter, if you people think that this is a completely unjust order, it's without natural justice, without jurisdiction, against the Supreme Court federal law, not passed by a proper officer, not passed by an officer who had no delegation. So all this you have to examine first. Technical issues you have to examine first. Do you get relief somewhere on technicalities? If yes, for example, refund order has been rejected by Assistant Commissioner involving amount of 10 crores. You have to see whether he is a proper officer. जो भी इनका notification जो भी आपके department का है, not a proper officer, you have no jurisdiction. High Court will never insist you to go through appeal because the order is non-est in the eyes of law, or order is not signed. Delhi has in many cases they say order is not signed, so will admit remand the matter with whatever observation they give. So therefore, once you are facing with a heavy demand case, you first spend time whether I'll tell you this, you presume the appeal was time barred and you have to move for condemnation application. Assume facts, forget the dates, write only the application of condemnation of delay along with affidavit. The second set of appeals you have to say is whether in a given situation this example of Yahoo wala appeal, how will you draft this appeal? I am not a taxable person. Therefore, section 9 cannot be invoked against me. That's the charging section. So you have 2 days. You can email it to me, sv@svconsultants.co.in, sv@svconsultants.co.in. It's also my website, or Rahul the email. I don't know, but Rahul has given his email on the WhatsApp group. नहीं इसको बोल देगा डाल देगा WhatsApp group पे यार. चला उसने. You have to draft these appeals yourself. Properly typed. English आप automatically check कर सकते हो अपने word पर. English की कोई problem नहीं होती. Whatever you know, apply your mind. इस section में आपको क्या लिखना है? Like for example, grain issue, section 9 is the charging section. It has to be a supply, taxable supply. So whether you are exemption under section 7 or any rate tax notification of 2017, you have to find that entry के grain की कहाँ taxability नहीं है. फिर उसको लिखना है कि क्यों आपके और आपको आपकी लायबिलिटी क्यों नहीं बनती रजिस्ट्रेशन की. क्या आप सेक्शन 24 में कवर नहीं होते, या आप कुछ और नहीं करते, आपने कोई रिवर्स चार्ज नहीं किया, आपने इंटरनेट सप्लाई नहीं की, आपने को TDS नहीं काटना, वो जो भी सेक्शन 24 के 13 ग्राउंड है आप उनमें कवर होते और नहीं होते. Then you have to write the factual matrix, you have to write the legal matrix, and then you have to write the prayer. कि आपकी क्या prayer है, along with the appeal forms you have to fill in. Document download करके you can fill in. So this will equip you with how to start drafting appeals. That is the purpose of this interactive session. Thank you so much.